Hello, my name is Stephen Labiak with the law offices of Stephen Labiak here in Fresno and Visalia, California, and welcome to Week 1 podcast. Today we're going to be talking about the dangers in your life when you decide to stop paying your credit cards. Now, most people don't just decide today, I'm just not going to pay my credit cards. No, something's happened. You lost your job, you were right-sized, you were outsized, you were downsized, maybe you were in a car accident, maybe some other tragedies befallen you. Life happened, and you know what? This month you just can't afford to pay the credit cards. It may just be one credit card. It may be a whole slew of credit cards. You just can't afford to pay anymore. So what I'm going to discuss today is what can happen to you when you decide to stop paying or that you can't pay, and what are some solutions to how to deal with these problems. The first thing you should expect when you stop making payments on your credit card, and this is generally being defined as at least more than 30 days late, is your credit rate will be reduced. What that means, if you have a limit of $3,000 and you were only using $1,500, expect that to cut back to that $1,500 on that credit card, and probably any other open credit cards you have as well. If you have an American Express card which has no limit, that will probably be cut off as well. You can expect your interest rates to skyrocket if you have a nice teaser rate of 3.9%, or if you're paying 14.9%. Expect that to hit the default rate, which is typically 24, 29, 36%, whatever they can get away with. Expect your rates to skyrocket. Further, also expect if you've had pristine credit, as soon as you're in that 30, 60, 90 day late on your credit cards, your credit rating is going to take a hit. In the grand scheme of things, your credit score is just that. It's just a score. It's a number. It's not an evaluation of how you are as a person, how you live your life, how you conduct yourself. It's just a number. But if you've decided, as a famous radio personality likes to say, worship at the altar of the mighty credit score, well, you know what? That's going to take a hit. But I'm going to be honest with you, your first priority needs taking care of your family, not taking care of your credit score. Anyway, you're not making your payments on your credit card. So now what do you expect? You do have maybe a little extra money in your pocket, but you're going to have somebody on your case, and that is going to be the credit card companies. Now, depending on the credit card company is going to depend on how aggressive they are, and it varies from company to company. I have my personal experiences. Other people have their personal experiences on who does what. Some may call you, some may immediately sue you. The ones that call you, they're going to call you at home. They're going to call you at work if they have a work number. They're going to call your cell phone. If they've managed to obtain a phone number for your parents or a significant other or somebody else, even remotely tangential, they may call that person. Now, is it annoying? Absolutely. Can you deal with it? I'm going to be honest with you. They are experts at what they do. Their job is to collect money. Okay? They are professionals at it. They are a lot better at it than I am. They are a lot better at it than you are at saying no. And what they're going to do is they're going to make it an emotional appeal. They're going to try to remove any and all facts going on of a logic to reason why you can't afford to pay, like, you lost your job, or that something tragic happens, you're in the hospital, your mother's sick and you're taking care of her. You know what? They don't care. They're going to use any emotional appeal, such as, don't you feel bad? Don't you have an obligation to pay this? Well, what about the money you're receiving from unemployment? Give us that. And they're going to keep on you with that, and it's going to be emotional. And they're going to set up a situation to where the only way it feels that you can release this emotional burden is to send them money. Don't. Whatever you do, don't send them money. Don't give them access to your bank account. Even if they promise they'll only take $50, they're going to take as much as they can. They are experts at this, and it's going to be an emotional appeal, and you just have to say no. Hang up. Run, hang up, do whatever you have to do, hang up. Now, understand that they may call other people, your work, your family, and things like that. Some people may say, well, the Fair Credit Report Act says they shouldn't be allowed to do this. You know what? You may be right in your case. But at the end of the day, are you going to sue them to make them stop? Probably not. As a lawyer, there are some that do that. It's something that I will entertain on occasion. But realistically, at the end of the day, are you going to spend all this money for a lawyer to stop a call when you can't pay your credit cards? Probably not. So realistically, it's something you have to deal with, at least in the short term, once you stop paying your credit cards. So you stop paying, pursuing the collections action by calling, and hopefully you're still not sending them any money because it's going to keep going. Now this is all assuming, by the way, that your financial situation is not going to change and you can afford to send them. I'm counting on this as being, at least long-term, 6-month financial situation. So what's their next steps? Well, sometimes they sell it to other debt collectors. Eventually, even if it's sold or they keep it, at some point they are going to sue you. Now, this means you're going to be hit with legal papers. You will get a summons and a complaint. What this is this the actual beginning process of them being able to legally collect on the debt. This means they have to prove in court that you owe the money and you haven't paid the money. Once you are served, you have 30 days to respond, typically. Always depends on your jurisdiction. Count on 30 days. It's not 30 days from the date on the court papers. It's 30 days from the date you're served. You can be served at work. You can be served at home. It just has to be left with a professional or responsible adult, we should say. Now, what's the definition of responsible adult? You know what? There's lots of court arguments on it. We just count on any person with, that has a pulse and it's left with, that's going to be a responsible adult. So you've been served. You have 30 days to respond. You got a couple options here. If you respond by yourself, I recommend you use what's called a general denial. That means you deny everything. If you want to, don't even admit that that's your name. Be honest, be realistic. Admit what's true to the best of your abilities. Say that is me and yeah, maybe I did have an account with them. The rest of it, just deny. Deny, 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 deny. It's not illegal, it's not immoral. It's your right to contest the allegations made in a civil case. If you do that, you do need to file it in wherever court, typically the same county and city of where you live. If you do it on your own, you typically have to pay a filing fee to that jurisdiction. Depending on whether they use small claims, limited civil, or unlimited civil, you will probably have to pay a filing fee. If you're currently having financial difficulties, you may ask for a waiver. Generally, the local courts are a little more lenient on granting those than the federal courts are. But if it's a limited civil case, you can expect to pay somewhere, around $350. If it's unlimited civil, around $400, and that's just in the fees to respond. That doesn't count you hiring a lawyer to respond for you. Typical attorneys charge, on average, about $1,000 to respond to a complaint. That's not taking the case to court. That's not representing you in court. That is typically just responding. Once you have responded, however, though, that's going to buy you a lot of time. Then the whole machinery of the court gets kicked into place. All this will depend on your jurisdiction and how fast your courts operate. But here in the Central Valley, once you've responded to a case, you typically will have about a year until the case will actually be heard in court. There will be some intermediary steps like to meet and confer, settlement offers maybe a summary judgment motion filed. But if you respond and keep responding and denying and use all the tactics available to you personally, you can delay it for about a year, which means you don't have to pay the debt for a year. You can even get a jury trial to say that you shouldn't pay the debt. Now, that's going to be difficult to convince a jury that you do not owe do not owe the credit card companies money. It's possible, but don't count on it. At some point, you're going to have to pay the money. So if you fought it all the way and you lose the case, you will have a judgment against you, and you will owe whatever the credit card company asked for. So if you owe them a couple $1,000s, let's say $2,000, count on $2,000. If they use a lawyer, add another $1,000 on there. That is fairly standard. If you did not respond to the initial filing, however, you will typically, within about 30 to 60 days after your 30-day deadline, the credit card companies will file a motion for basically summary judgment because you did not respond, and you lose the case at that point. So now you have a judgment against you, whether you did respond or you didn't respond. Just the only difference is going to be how long until you get that judgment. Now they have a judgment. What does that mean? That means they legally can ask the sheriff to come take your money. So how do they get the money? Well, two most common ways are to levy your bank account and levy your paycheck. Levying your bank account means they find out where your bank account's at, probably from a check you've written them in the past or a direct transfer, and they go to that bank account and they will wipe your bank account out. So if you have $1,000 in there, they will take $900, and the other $100 ends up actually going to your bank, who charges you a service fee for this privilege of taking your money. I know, isn't that great? So, number one, they levy your bank account. Number two, they levy your paycheck. They can take up to 25% of your take-home pay from your paycheck. Now, if you're not making a lot of money, if you're not working, they can obviously have no paychecks to levy. If you have other obligations that are higher than that, such as a tax levy or child support levy, those do get paid first before the court judgment does. But at some point, those will be paid off, and they will be coming to your paycheck, and they will take up to 25% to satisfy the judgment. And I can guarantee you your employer is going to enforce that, because if your employer doesn't, then your employer becomes on the hook for that money. So, but let's say, you know what, you don't have a job, you keep all your money in cash in the mattress, you don't have the bank account, so what else can they do to you? Well, if you own real property, you know, a house, bare land, they can file a lien in the county. What that means is you cannot transfer title or get a loan on that property until that lien is satisfied. So it's just going to sit there, and it has to be renewed every 10 years, but it will just sit there until there is a change in title or a loan taken out on the property. And at that point it will get paid, so it does not go away. Another option they have, and this is something, while it's not new on the books, it's new to being enforced, is if somebody has a civil judgment against you, they can, in the state of California, they can suspend your driver's license. This is not something that is widely known yet, but it is starting to happen more and more often. I'm just going to read here and quote here from California Vehicle Code section 16370, which states, the department, meaning the Department of Motor Vehicles, shall suspend the privilege of any person to operate a motor vehicle upon receiving a certified copy of a judgment or a certified copy of the Register of Actions in an action resulting in a judgment of damages if that person is not paid on that judgment within 30 days. Long story short, they have a civil judgment against you, they can suspend your driver's license until you're paying on that judgment. Now, if you are caught driving without a driver's license, guess what? Now you have other civil penalties, plus it is possible for criminal penalties, although cops usually are not too aggressive on making criminal charges for driving without a license. So, these are all the things that can happen to you if you don't pay a civil judgment. Now, what about going to jail? You will often hear the credit card companies, debt collectors, threatening you with sending you to jail if you do not pay the money. And you may have even heard anecdotally, well, this person went to jail because they didn't pay their debts. That's actually not true outside of child support. As long as it's not child support. We deal with just the credit cards here. So, how do people end up in jail? Well, when you have a judgment, there is something called an order of an examination. What that is that's a legal order from the court for you to appear, for you to explain why you haven't paid your debt to the person who won the judgment against you. You just have to show up and say, you know what, Your Honor, I'm broke. I have no money, my mom's in the hospital, my dog died, I lost my job, I was right-sized, Newt Gingrich didn't win the presidential nomination. Whatever the reason is, you don't have any money to pay the judgment. And that's okay. You just have to show up and explain yourself to the judge. The problem is, people do not show up for the order of examination. Now, the key here is what is called an order of an examination. What is that? That's an order. That means the judge has ordered you to show up. Judges do not like it when people refuse their orders. So what happens if you don't show up for an order of examination? A bench warrant can be issued against you because you failed to appear. Okay? So the next time you get pulled over for a traffic stop or any interaction with the police pull up your record, they see that bench warrant, guess what? You just got arrested. Did you get arrested for not paying your debts? No. You got arrested because a judge gave you a lawful order to show up in court to appear, to explain to the judge as to why you haven't paid your debts. And that is why people get arrested for not paying their debts. It's not because they didn't pay them, it's because the judge gave them an order. So, what's the thing to learn here? If a judge gives you an order, you need to follow it. So what can we do to prevent all this? Well, if you're in the situation your wages are getting garnished, you're not paying your bills, you're struggling with life, this is when it may be a good time to consult a bankruptcy attorney. That's what I do. That's how I try to help people. And bankruptcy is one of the ways that can help take care of these problems. For more information about this or anything else, give me a call at 559-274 or 2868, or visit me at Labiak Law, and I'll see what I can do for you. Thank you for your time.